Welcome to LexTalks Legal Topics, Simplified, your companion for exploring the fascinating world of law. Today, we're
Huh.
diving deep into the executive and legislative branches of the Indian Constitution,
Okay.
a topic I know can feel a bit overwhelming, especially in those early semesters of law school.
It's true. The Indian Constitution is incredibly detailed,
Yeah.
but that's because it lays the foundation for our entire system of governance.
Right.
We've got some great resources to help us unpack it all, including legal texts,
Yeah.
articles, and even government websites.
I was going through the material, and one thing that jumped out at me was this concept of territoriality of executive power from an article I found online.
Hmm.
It talks about the transfer of prisoners between states. What happens when a prisoner is moved to another state? Which state holds the power to remit their sentence?
That's a really interesting question, and it highlights how a seemingly simple situation can raise complex legal issues.
Yeah.
The article points out that there have actually been conflicting interpretations on this matter, even reaching the Supreme Court.
Okay, so let's break this down. What are the arguments for each side?
Well, in some cases, the Supreme Court has held that the transferring state where the prisoner was originally convicted retains the power to remit the sentence.
Okay.
But the article argues that this might not be the most logical approach based on the Constitution,
Why not?
because Article 162 of the Constitution says that a state's executive power applies to matters where the state legislature has the power to make laws. So if the receiving state has laws governing prisons and prisoners within its borders, shouldn't they also have the power to remit sentences?
It does seem more consistent. What are the practical implications of this legal debate?
It raises all sorts of questions about jurisdiction, the rights of prisoners, and the relationship between states within our federal system. Imagine a scenario where a prisoner is transferred to a state with more lenient sentencing guidelines. Does that mean they have a better chance of early release?
Hmm.
These are the kinds of issues that lawyers and judges have to grapple with.
It's fascinating how a single case can open up so many layers of legal complexity. Let's shift gears a bit and talk about the President of India.
Okay.
One of the sources we have is a government website that outlines the president's role qualifications and even their salary.
Yeah, it's easy to think of the president as a mostly ceremonial figurehead,
Right.
but they actually have some significant powers, even if they're often exercised on the advice of the Council of Ministers.
Right, like appointing the prime minister.
Right.
But I was surprised to learn they can be impeached.
Mm-hmm.
I always thought that was something that only happened in other countries.
It's true, and the process is laid out in Article 61 of the Constitution.
Okay.
It's not a simple majority vote either.
Right.
It requires a two-thirds majority in both houses of Parliament.
Wow, that's a high bar.
Yeah.
So to become president, you need to be a citizen of India, at least 35 years old, and qualify to be a member of the Lok Sabha.
Right.
But I read that you can't hold any other government position while serving as president. Talk about a career change.
And their emoluments can't be reduced during their term either. The current salary is fixed at 5 lakh per month, which is set by Parliament.
I guess that makes sense to ensure the independence of the office. Now, the president takes an oath, right? Who administers that?
The Chief Justice of India, or if they're unavailable, the next senior-most judge of the Supreme Court.
Okay.
It really underscores the significance and formality of assuming the presidency.
Definitely not just a handshake and a photo op.
Right.
Okay, let's talk about the prime minister. One of the articles we have calls them the real executive authority.
That's a key distinction to understand. While the president is the head of state, the prime minister holds the de facto executive power.
Okay.
They're the ones steering the ship, so to speak.
Yet unlike the president who is elected by an electoral college, the prime minister is selected by securing a majority in the Lok Sabha.
Right.
They have to meet certain eligibility criteria too, right?
Absolutely. They need to be a citizen of India and at least 25 years old if they're from the Lok Sabha,
Okay.
or 30 years old if they're from the Rajya Sabha.
Their responsibilities seem pretty extensive.
Yeah.
What are some of the key things the prime minister does?
Well, they appoint the Council of Ministers,
Uh-huh.
make crucial appointments like the Comptroller and Auditor General,
Sure.
TAGA and Union Public Service Commission, UPSC members, guide
Yeah.
foreign policy. It's a long list.
Speaking of the Council of Ministers, I remember learning about a limit on how many ministers there can be.
Right, that came about with the 91st Amendment Act of 2003. The total number of ministers, including the Prime Minister, can't exceed 15% of the total strength of the Lok Sabha.
So that's a way to ensure some balance within the government. Now let's step into Parliament. I think a lot of people, even law students, are a bit fuzzy on how things actually work there.
It's definitely a complex system with all sorts of procedures and figures that ensure things run smoothly.
Right.
We have the speaker, the deputy speaker, and even a pro tem speaker.
Okay, break that down for us. What's the pro tem speaker all about?
Think of them as the temporary stand-in. They're the senior-most member of Lok Sabha, and their main job is to preside over the oath-taking session for newly elected members.
Okay,
It's a crucial role in getting the new Lok Sabha up and running.
that makes sense. And then we have the deputy speaker who steps in when the speaker is absent, right?
Exactly. They're elected for a 5-year term by the Lok Sabha members and play a vital role in maintaining order and continuity during those times.
Now, one thing I've always been curious about is 0 hour.
Hmm.
I hear about it on the news all the time, but what exactly is it?
It's a unique feature of the Indian parliament.
Okay.
Imagine a sudden event of national importance happens. 0 hour is the time right after question hour when members can raise these urgent matters even if they weren't on the planned agenda.
So it's a way to force a discussion on something critical that needs immediate attention.
Exactly. It gives members a way to hold the government accountable and to ensure that urgent issues don't get swept under the rug.
That's pretty powerful.
Yes.
Then there are motions, which I know can really shape the course of things in Parliament.
Ah, yes, motions are like the tools of parliamentary debate. We have all sorts of them.
Okay.
Calling attention motions,
Ah,
which let members raise specific issues and make brief comments.
Okay.
Adjournment motions, which can halt regular business to discuss urgent matters.
okay.
And of course, the big one, the no confidence motion.
That's the one that can bring down the government.
Yes, if it passes, the entire Council of Ministers has to resign. It's a high-stakes move that can lead to major political shifts. And then we have censure motions, which are specifically for criticizing the government's actions.
So these motions are how members push for accountability and action within the government. Now let's zoom in on the states. They have their own executive and legislative branches.
Right.
It's like a mini version of the central government.
That's a good way to think about it.
Hmm.
The states have their own governors appointed by the president, who are the heads of state at the state level.
Oh.
They have unique powers and responsibilities outlined in the Constitution, kind of like guardians of the state's constitution.
And similar to how the prime minister leads the central government, we have the chief minister and their council of ministers at the state level.
Right, exactly. They handle state-specific matters, driving legislation and administration within their state. Think of them as the Prime Minister and Council of Ministers, but with a regional focus.
So how is the chief minister chosen? Is it similar to how the prime minister is selected?
Yes, very similar. Typically, the leader of the party with the majority in the Vidhan Sabha becomes the chief minister. The governor then formally appoints them.
It's fascinating how the state-level structure mirrors the central government, but with a focus on regional issues.
It's a reflection of India's federal structure where power is divided between the union and the states. It's a system that allows for both national unity and regional diversity.
Okay, before we move on to the next part of our deep dive,
Yeah.
I think we should equip our listeners with a quick reference guide to some key constitutional articles related to these branches of government.
Absolutely.
It's not just about memorizing article numbers, but about understanding how they shape the balance of power in India. Let's start with the foundation. Article 52 establishes the office of the President of India.
And right after that, Article 53 clarifies that the president holds the executive power of the union,
Right.
which is a huge responsibility.
And then we have Article 73, which outlines the extent of the union's executive power. It's about defining the boundaries of where the central government's authority lies.
So it's about drawing lines between what the union government can do and what is left to the states to decide.
Exactly. Now, Article 74 talks about the Council of Ministers who aid and advise the president in carrying out their duties. Remember, the president often acts on their advice, so this article is key to understanding that dynamic.
Right. And to delve further into that relationship, we have Article 75, which outlines the appointment and responsibilities of both the Prime Minister and the Council of Ministers.
And let's not forget Article 123, which gives the president the power to issue ordinances when Parliament isn't in session. It's like a fast-track lawmaking mechanism for urgent situations.
Moving on to the legislative branch, we have Article 79, which establishes the Parliament of India with the President and the two houses, the Lok Sabha and the Rajya Sabha.
And then we have Articles 80 and 81, which outline the composition of the Rajya Sabha, representing the states and union territories, and the Lok Sabha representing the people directly.
To ensure smooth functioning, Article 117 empowers Parliament to set its own rules of procedure. So they have a lot of autonomy in managing their own affairs.
Now, shifting focus to the states, Article 153 mirrors Article 52 at the central level, establishing the office of the governor for each state.
And just like Article 53 gives executive power to the president at the union level, Article 154 vests the same power in the governor at the state level.
Article 162 is crucial because it defines the extent of the state's executive power, clarifying the division of powers between the union and the states.
And just like the president can issue ordinances at the union level, Article 213 grants the governor the power to issue ordinances at the state level when the state legislature is not in session.
Remember, these articles aren't just about rote memorization. They represent the framework for how power is structured and exercised in India.
It's about understanding the principles behind those articles and how they work together to shape the political landscape of India.
Exactly. These articles are the building blocks of our democracy. Now, before we wrap up this part of our deep dive, let's delve into the principle of collective responsibility, a concept that's really at the heart of parliamentary democracy.
This principle means that the entire Council of Ministers is collectively responsible to the Lok Sabha for the actions and policies of the government.
So it's not about individual ministers acting on their own. It's about the government functioning as a unified body accountable to the legislature.
Precisely. And if the Lok Sabha loses confidence in the government, the entire Council of Ministers has to resign.
It's a powerful way to ensure accountability and prevent any one minister from becoming too independent.
Absolutely. It's a key part of maintaining that balance of power that we've been talking about. Now let's bring this concept to life with a case example. We'll discuss Rai Sahib Ramjawaya Kapoor v. State of Punjab, a landmark judgment from 1955.
Okay.
This case clarified that executive function goes beyond just day-to-day administration. It includes shaping policy, initiating legislation, maintaining order, and promoting social and economic welfare.
So how did this case connect to the idea of collective responsibility?
While it didn't directly deal with that specific concept, it established important principles about the scope of executive power and how it's exercised,
Okay.
which has implications for how we understand the collective responsibility of the Council of Ministers. It's a case worth revisiting for anyone studying Indian constitutional law.
Definitely. Now let's talk about a figure who often gets overshadowed, the vice president. They're part of the executive branch, but their primary role is as the ex officio chairman of the Rajya Sabha.
It's an interesting duality.
Yeah.
They're part of the executive, but also play a key role in the legislature as the presiding officer of the upper house.
And if the president's office becomes vacant, the vice president steps in.
Exactly.
Hmm.
They can act as president for up to 6 months, during which a new president must be elected.
Okay.
They also step in if the president is temporarily unable to fulfill their duties for any reason.
So they're kind of like the backup quarterback for the country.
Yeah.
And speaking of backup players, let's not forget the deputy speaker and the pro tem speaker who we discussed earlier. They're crucial for ensuring the smooth functioning of Parliament, especially when the speaker is absent.
Their roles might seem secondary, but they're essential for maintaining continuity and order in the Lok Sabha.
It's all about having a system in place that can adapt to different situations. Now, I know Parliament doesn't just meet whenever it feels like it. Can you explain the typical schedule of sessions?
Sure, there are usually 3 main sessions: the budget session, the monsoon session, and the winter session. The budget session is usually the longest, starting in February and going until May.
That's when the government presents its annual budget, right?
Exactly. It's a time for intense debates and discussions about the country's finances and economic policies.
And the monsoon session typically takes place in July and August, right?
That's right. It's generally focused on legislative work and debates on various issues of national importance.
And finally, the winter session, which is usually November and December.
Yes, it tends to be the shortest session and is often about wrapping up any pending legislative business before the year ends.
So this structured schedule ensures that there's time dedicated to both financial matters and broader legislative issues.
It's a system that's evolved over time to handle the vast responsibilities of the Indian Parliament. Now let's circle back to the states and take a closer look at the governor's role. We know they're appointed by the president and act as the head of state at the state level, but what are some of their specific powers? They have a diverse range of powers spanning executive, legislative, financial, and even judicial areas. They appoint the chief minister and other ministers on the advice of the chief minister. They also appoint the advocate general of the state and determine their remuneration.
It sounds like they have a significant hand in shaping the state government.
They certainly do. In terms of legislative powers, they can summon and dissolve the state legislature, give assent to bills, and even reserve certain bills for the president's consideration.
And their financial powers.
They're responsible for making sure the state budget gets presented to the legislature and that all spending is done according to the law.
And lastly, their judicial powers. What do those entail?
The governor has the power to grant pardons, reprieves, and remissions of punishment. They can also suspend, remit, or commute the sentence of someone convicted of an offense under state law.
Wow, that's a lot of responsibility.
Yeah,
It's like they're a mini president for their state.
in some ways, yes. And just like with the president, it's important to remember that the governor often acts on the advice of their council of ministers, but they do have certain discretionary powers as well. Now, before we move on to the next part of our deep dive, let's quickly go over the qualifications someone needs to meet to become a governor.
Okay.
Well, Article 157 of the Constitution lays it all out. First, they have to be a citizen of India, which is a given.
Makes sense. What else is there?
They also need to be at least 35 years old, just like the president.
So experience and maturity are clearly valued for this position.
Absolutely. And finally, they can't hold any other office of profit. This ensures that their focus is solely on their duties as governor. Now, let's shift gears and talk about the legislative process at the state level. I know we have the Legislative Assembly, but some states also have a Legislative Council, right?
Exactly. In states with a bicameral legislature, the process involves both the Legislative Assembly,
Okay.
which is the lower house directly elected by the people,
Right.
and the Legislative Council, the upper house, with members elected indirectly.
And in states with a unicameral legislature, it's just the Legislative Assembly responsible for making laws.
Precisely.
So for those states with both houses, how does a bill become law?
The process is similar to how it works at the central level. First, the bill is introduced in either the Assembly or the Council.
Okay.
Then it goes through readings and debates in both houses.
What if the two houses can't agree on a bill?
There are ways to work through those disagreements. Sometimes the bill will go to a joint sitting of both houses to hash things out and vote.
And once a bill is passed by both houses, what happens next? It goes to the governor for their assent.
And if the governor agrees,
It becomes law. But if they don't agree, they can withhold assent or reserve it for the president's consideration.
so the president has the final say in those cases.
That's right.
It's interesting how the state legislative process involves a balance of power not only between the two houses, but also between the state and the union.
It's a reflection of the federal nature of India's government, ensuring that both the states and the union have a role in the lawmaking process. And just like in Parliament, money bills have a special procedure at the state level.
Right, so they can only be introduced in the Legislative Assembly.
Exactly. Once the Assembly passes a money bill, it's sent to the Legislative Council, which can make recommendations, but they can't reject it.
So ultimately, the Legislative Assembly has the final say on money matters.
Precisely. It ensures the state has control over its own finances. Now let's switch gears and talk about those special powers the president has in emergencies. We're talking about national emergencies, state emergencies, and financial emergencies. Right. Exactly. Article 352 empowers the president to declare a national emergency if the security of India or any part of it is threatened by war, external aggression, or armed rebellion.
So it's not something that happens every day. It's a serious power reserved for extreme circumstances.
Absolutely. And when a national emergency is declared, the union government's powers expand significantly.
Okay.
They can make laws on matters that are usually under the state's jurisdiction and even restrict fundamental rights to a certain extent.
It's like shifting into crisis mode, where
Yeah.
the central government takes the reins to address the threat.
You could say that. It's a drastic measure, but one that's seen as necessary in certain situations to protect the nation's security and integrity.
Now, the president can also declare a state emergency under Article 356, right?
That's right. This is what's often referred to as president's rule. It's invoked if the president believes that a state government can't function according to the Constitution.
What are some of the reasons why this might happen?
It could be a complete breakdown of law and order,
Okay.
political instability, a failure of the state machinery, or anything else that prevents the state government from working as it should.
So the union government essentially steps in and takes control.
Yes, and it's a controversial power that has been debated extensively.
Right.
There have been instances where critics argue that president's rule was imposed for political reasons rather than genuine concerns about the state's functioning.
It's a tricky balance between ensuring the smooth functioning of states and respecting their autonomy.
Absolutely. It highlights the tension that can exist between the union's responsibility for the whole country and the state's right to govern themselves.
Now, the third type of emergency is a financial emergency declared under Article 360. This one comes into play when the financial stability of India or any part of it is threatened.
Exactly. It gives the union government the power to implement drastic measures to control spending, reduce salaries, and try to stabilize the economy.
I imagine that's not a popular move, especially if it means cutting salaries.
You're right, it's not. And there are critics who argue that this power could be misused to curtail the financial autonomy of states and impose harsh austerity measures.
So all three types of emergency powers, while intended for exceptional circumstances, also raise important questions about the potential for abuse and the balance of power between the union and the states.
Absolutely. They highlight the delicate balance between security and individual rights, between the need for decisive action in a crisis, and the importance of respecting democratic principles.
Now let's delve into a few more key constitutional articles. Article 72 deals with the president's power to pardon.
It's a significant power that allows the president to grant pardons, reprieves, respites, and remissions of punishment,
Okay.
or to suspend, remit, or commute the sentence of any person convicted of any offense.
So the president can essentially overturn or reduce punishments given by the courts.
Yes, and it acts as a check on the judiciary. It recognizes that there may be situations where mercy or leniency is warranted.
It's fascinating how the Constitution tries to prevent any one branch from having absolute power by creating these checks and balances.
Yeah,
But this power isn't unlimited, right?
that's right. The Supreme Court has ruled that the president must exercise the pardoning power on the advice of the central government, and that advice is binding. It's not a decision the president can make unilaterally.
Okay, now let's shift our focus to the legislative process and talk about motions, which are essential tools in Parliament.
Think of motions as the formal proposals or requests made by members of Parliament to initiate debates, make decisions, and guide the legislative process.
Can you give us some examples of the different types of motions used in Parliament?
Sure, we have calling attention motions, which are used to bring urgent matters to the government's attention,
Okay.
adjournment motions, which allow the House to set aside regular business to discuss urgent matters,
Okay.
and no confidence motions, which can potentially bring down the government if they pass.
And then there are censure motions, which are specifically for criticizing the government's actions.
Exactly. These motions are the mechanisms through which Parliament debates issues, holds the government accountable, and ultimately makes decisions on matters of national importance.
One motion that often gets a lot of attention is the adjournment motion. Why is that?
Because it allows members to interrupt the regular flow of business to discuss something they consider incredibly urgent and important. It's a way to force the government to address a pressing issue right then and there.
So it's a powerful tool for members of Parliament to hold the government accountable and ensure that urgent matters aren't ignored.
Precisely. And because it can disrupt the planned proceedings, opposition parties often use it strategically to raise sensitive issues and put the government on the spot.
Okay, before we move on, I want to make sure our listeners understand 0 hour.
Yeah.
It's another term that comes up a lot when talking about Parliament.
0 hour happens immediately after question hour and before the day's scheduled business begins. It's a time when members can raise any issue they want, even if it's not on the agenda.
So it's like an open mic section for members of Parliament.
In a way, yes. It
Yeah.
ensures that important issues don't get overlooked just because they weren't planned for.
And it gives members another opportunity to hold the government accountable and raise public awareness about their concerns.
Absolutely. 0 hour is a vital part of the Indian parliamentary system. Now let's shift gears and talk about the concept of office of profit. It might sound a bit obscure, but it's really important for understanding how to prevent conflicts of interest within the government.
Right.
An office of profit is essentially any position that could lead to financial gain or benefit.
And why is that significant for members of Parliament?
The Indian Constitution says that if someone holds an office of profit under the government, they can't be a member of Parliament. This is to prevent them from using their position in Parliament for personal gain and to ensure they're loyal to their constituents and the country.
So it's a safeguard against corruption and undue influence.
Exactly. The idea is to keep things clean and make sure that those in power are serving the public interest, not their own wallets. Now, before we wrap up this part of our deep dive, I want to touch on the Election Commission of India. They're kind of the referees of our democracy, making sure elections are free and fair.
Absolutely. They're a constitutional body, which means they're independent of the government. This independence is crucial for ensuring that elections are conducted impartially and that the results truly reflect the will of the people.
So they oversee everything from voter registration to the counting of votes.
Exactly.
Yeah.
They also delimit constituencies, prepare electoral rolls, and enforce the model code of conduct during elections. Their job is to maintain the integrity of the entire electoral process.
It's a huge responsibility, but one that's absolutely essential for a functioning democracy. This has been a great overview of the executive and legislative branches of the Indian Constitution. I hope our listeners are starting to feel a bit more comfortable navigating this complex world.
I agree. We've covered a lot of ground, but there's still so much more to explore. Be sure to join us for Part 2, where we'll dive into more case studies, delve into some of the finer points of legislative procedure, and continue to unpack the intricate workings of these crucial branches of government.
Yeah.
Welcome back to LexTalks. We're continuing our deep dive into the Indian Constitution's executive and legislative branches. Remember, we're breaking down complex legal concepts in a way that's easy to understand, especially for you law students out there.
Exactly. We've got a lot more to uncover, so let's jump right back in. In this part of our deep dive, I want to circle back to that fascinating question we touched on earlier about the territorial limits of executive power.
You mean that case about the transfer of prisoners between states? The one where it's unclear which state has the power to remit the prisoner's sentence?
Precisely. It's a perfect example of how seemingly straightforward situations can raise complicated legal issues. We touched on it briefly before, but it's worth exploring in more detail.
Okay, so let's recap. The article we read argues that the receiving state, the one where the prisoner is actually serving their sentence, should logically have the power to remit the sentence, right?
That's right. The article argues that this interpretation is more in line with Article 162 of the Constitution, which says that a state's executive power extends to matters where the state legislature has the power to make laws. If the receiving state has laws governing prisons and prisoners within its borders, it stands to reason that they should also have the power to remit sentences.
It seems logical when you put it that way.
Mhm.
But haven't there been Supreme Court cases that went the other way, saying the transferring state retains the power?
You're right. In cases like Ratan Singh and Ajit Singh, the Supreme Court held that the transferring state retains the power. However, the article we're discussing argues that those decisions might not be completely sound in light of Article 162.
So we have a bit of a legal tug-of-war here, with different interpretations of the Constitution and even conflicting Supreme Court judgments. What does this tell us about the law in this area?
It highlights how legal interpretation is often a nuanced and evolving process. There isn't always a clear-cut answer, and different perspectives can lead to different conclusions. As law students, it's crucial for you to develop the skills to analyze these complexities and to form your own informed opinions.
It's a good reminder that we shouldn't just blindly accept what we read or hear. We need to think critically and question things.
Absolutely. Now let's shift gears and talk about a mechanism that allows the executive branch to act swiftly when Parliament is not in session: ordinances.
Right, ordinances. I remember learning about them, but always found them a bit confusing. Can you break it down for us?
Think of ordinances as temporary laws that the president can issue when Parliament is not in session. It's essentially a way to address urgent matters that can't wait for the full legislative process.
So it's like a fast-track lane for lawmaking.
Exactly. Article 123 of the Constitution gives the president this power, but there's a catch. Ordinances have to be presented to both houses of Parliament when it comes back into session.
So Parliament gets the final say.
Absolutely. Parliament can choose to approve the ordinance, in which case it becomes a permanent law. Or they can disapprove it and it ceases to operate. It's another example of the checks and balances built into our Constitution.
So the president can act quickly in an emergency, but Parliament ultimately retains its legislative authority.
Precisely. Now, the power to issue ordinances has been a subject of debate, with some arguing that it's been used excessively by governments to bypass parliamentary scrutiny. It raises questions about the balance of power between the executive and legislative branches.
It's a good example of how the Constitution provides a framework, but the way it's interpreted and applied can vary depending on the circumstances.
Exactly. Now let's move on to another key aspect of the executive branch, the president's power to appoint various officials. One of the most important appointments is the Comptroller and Auditor General of India, or CAG.
The CAG is a pretty big deal, right?
Right.
They're responsible for auditing the accounts of the union and the states, making sure public money is being spent properly.
You got it. They're like the financial watchdogs of the government. They audit the accounts of various government entities and ensure that funds are used responsibly and transparently.
And their independence is crucial, right? You wouldn't want them to be influenced by the very people they're auditing.
Exactly. That's why the CAG is appointed by the president, but functions independently of the government. Their reports are presented directly to Parliament and often shed light on any financial irregularities or mismanagement.
It's like a built-in accountability mechanism.
Okay, let's shift back to the legislative process for a bit. We talked about money bills earlier, but there are other types of bills that Parliament deals with, right?
Absolutely. Apart from money bills, we have ordinary bills, financial bills, and constitutional amendment bills. Ordinary bills cover a wide range of matters that fall under Parliament's jurisdiction.
So those are the most common type of bills.
You could say that they deal with everything from education and healthcare to environmental protection and criminal law.
Okay, and how are financial bills different from money bills? I always get those mixed up. Financial bills also deal with money matters. But unlike money bills, which can only be introduced in the Lok Sabha, financial bills can be introduced in either House of Parliament. And the Rajya Sabha has more power to amend them.
So they're subject to more debate and scrutiny.
Exactly. And finally, we have constitutional amendment bills, which are used to well amend the Constitution itself.
And changing the Constitution is a pretty big deal, right?
You bet. It's not something to be taken lightly. That's why constitutional amendment bills have a much stricter process for passage. They need a special majority in both houses of Parliament, a majority of the total membership of each house, and a 2/3 majority of the members present and voting.
So a much higher bar than for ordinary or financial bills.
Yeah.
It ensures that any changes to the Constitution have broad support.
Precisely. It's all about safeguarding the foundation of our democracy.
Now let's talk about something that's often in the news, especially when there's a big vote in Parliament, whipping.
Ugh.
Whipping. It's all about maintaining party discipline. Each political party has a whip whose job is to make sure their members vote according to the party line.
So they're kind of like the party enforcers, making sure everyone falls in line.
You can see it that way. They use a combination of persuasion incentives and sometimes even threats to ensure that party members toe the line.
It sounds like a pretty powerful tool for maintaining party unity.
It is, especially in India, where coalition governments are common. Whipping becomes crucial to ensure that the government can pass its legislation.
But doesn't it also raise concerns about the independence of individual members of parliament? What if they disagree with their party on a particular issue?
That's a valid point. Some argue that whipping stifles dissent and prevents MPs from voting according to their conscience.
It's another example of how there are often competing interests at play in our democratic system.
Exactly. Now let's switch gears and talk about a concept that's crucial for understanding how legislative power is divided between the Union and the states, the seventh schedule of the Constitution. The seventh schedule. That's the one with the 3 lists, right?
That's right. We have the Union list, the state list, and the concurrent list. The Union list contains subjects over which only the Union Parliament can make laws. These are typically matters of national importance, like defense, foreign affairs, and currency.
Okay, so matters that affect the entire country.
Exactly. Then we have the state list, which contains subjects where only the state legislatures have the power to make laws. These are usually matters specific to a particular state, like public health, agriculture, and local government.
So things that vary from state to state.
Right. And then there's the concurrent list, which covers subjects where both the Union Parliament and the state legislatures can make laws. These are areas where there's both national and regional significance, like education, forests, and criminal law.
So what happens if there's a conflict between a union law and a state law on a matter that's on the concurrent list? Who wins?
That's where Article 254 of the Constitution comes in. It says that in case of a conflict, the Union law will prevail. But there are exceptions, like when a state law receives the president's assent after being reserved for their consideration.
It sounds pretty complicated.
It can be, but the seventh schedule is a cornerstone of Indian federalism. It's a way to balance the need for a unified nation with the recognition that states have their own unique needs and priorities.
It's all about finding that delicate balance between unity and diversity. Now, do you have any examples of how these conflicts between union and state powers have played out in real life?
Absolutely. A classic case is State of Bombay versus FM Balsara from 1951. It involved a challenge to the Bombay Prohibition Act, which banned the sale and consumption of alcohol in the state.
So a dry state situation.
Exactly. The question before the Supreme Court was whether the state legislature actually had the power to enact such a law.
And which list did the subject of alcohol fall under at that time?
It was on the state list, but there were some entries on the union list, like import and export, that could overlap with the state's power to regulate alcohol.
So there was potential for conflict.
You got it. The Supreme Court had to analyze the relevant entries in the seventh schedule and decide whether the state law was valid.
And what was the verdict?
The court upheld the Bombay Prohibition Act, ruling that the state legislature had the power to regulate alcohol within its territory, even if those laws had some indirect impact on matters in the union list.
So the state's power to regulate alcohol within its own borders trumped the union's powers related to import and export in this case.
That's right. It's a great example of how the courts have to interpret the Constitution to resolve conflicts between union and state powers.
And those interpretations can have a huge impact on people's lives. In this case, it meant the difference between being able to buy a beer in Bombay or not.
Exactly. It shows how these legal concepts have real-world consequences.
Now let's move on to a mechanism that's crucial for holding the government accountable and keeping the public informed: parliamentary questions.
Parliamentary questions are a powerful tool. They allow members of parliament to directly question the government on any matter.
So it's like a Q&A session with the government.
You could say that members can submit written questions, and the government is obligated to provide written responses, which are typically read out in Parliament.
It sounds like a straightforward way to get information from the government and keep them on their toes.
It is. And it's not just about getting answers. The questions and answers are recorded in the parliamentary record, which means they're open to public scrutiny.
So it promotes transparency and accountability.
Exactly. And parliamentary questions can also be used strategically to highlight problems, raise concerns, and put pressure on the government to address specific issues.
It's a way for MPs to act as watchdogs on behalf of the people they represent.
You got it. Now, before we wrap up this part, let's talk about another important element of the legislative process: parliamentary committees.
Parliamentary committees. I remember hearing about them, but I'm not really sure what they do.
Think of them as specialized groups within Parliament that dive deep into specific issues. They examine bills and policies in detail, providing a forum for in-depth discussion and scrutiny.
So it's like having expert panels within Parliament to analyze things more carefully.
That's a good way to put it. We have standing committees, which are permanent committees that focus on specific ministries or departments. We also have select committees, which are formed for a specific purpose and disbanded once their task is done.
So they bring a more focused expertise to the table.
Exactly. They can dissect bills and policies with a fine-tooth comb, which isn't always possible in the full House. They also provide a platform for members of different parties to work together and find common ground.
So they encourage collaboration and consensus building.
Absolutely. And importantly, parliamentary committees play a crucial role in holding the government accountable. They can summon ministers and officials to appear before them to answer questions about their actions.
So it's like a mini trial within Parliament where the government has to explain itself.
You could see it that way. It adds another layer of scrutiny and helps ensure transparency and good governance.
Wow, we've covered a lot of ground today. We talked about the territorial limits of executive power, the power of ordinances, the role of the CAG, the different types of bills, the practice of whimming the division of powers between the union and the states, parliamentary questions and parliamentary committees. It's a lot to digest.
It is. But I hope our listeners are starting to see the connections between these different concepts and how they all fit together to form the complex tapestry of Indian democracy.
It's like we've been piecing together a puzzle, and now we're starting to see the bigger picture.
Exactly. And in part 3, we'll continue to explore this fascinating puzzle, delving deeper into case studies and legislative procedures, and we'll leave you with some final thoughts to ponder as you continue your legal journey.
Welcome back to LexTalks. It feels like we've been on quite a journey exploring the executive and legislative branches of the Indian Constitution.
We've covered a lot of ground, from the powers of the president and the prime minister to the intricacies of parliamentary procedures and the division of powers between the union and the states.
And we've seen how these concepts play out in real-life cases and situations, shaping the way our government functions and impacting the lives of citizens. It's been fascinating to see how the Constitution isn't just a static document, but a living framework that's constantly being interpreted and applied in new ways.
You hit the nail on the head. The Indian Constitution is a dynamic document that has stood the test of time. And understanding its provisions is not just about memorizing articles and legal jargon. It's about grasping the principles that underpin our democracy, the values it upholds, and the ongoing dialogue between different branches of government as they grapple with complex challenges.
It's about appreciating the delicate balance of power that the Constitution establishes, the checks and balances that prevent any one person or entity from having too much control.
Absolutely. And as future legal professionals, it's crucial for you, our listeners, to approach constitutional law with a critical and engaged mind. Don't just accept things at face value. Question assumptions, consider different perspectives, and recognize that the interpretation of the Constitution is an ongoing process shaped by societal changes and legal precedents.
It's like we're all part of this grand conversation about what the Constitution means and how it should be applied in the 21st century.
Precisely. And that conversation is constantly evolving. Now, before we wrap up our deep dive, I want to leave you with a final thought to ponder. We've discussed the formal powers and responsibilities of the executive and legislative branches, but what about the informal influences that shape their actions?
You mean things like public opinion, media pressure, lobbying efforts, and the dynamics of party politics?
Exactly. These factors might not be written in the Constitution, but they play a huge role in how the government operates in practice.
It's a reminder that constitutional law isn't just about the black and white of the text. It's also about the gray areas, the nuances and the interplay of various forces that shape how our democracy functions.
Well said. So as you continue your legal studies, remember to look beyond the text of the Constitution and consider the broader context in which it operates. That's where things get really interesting.
Thank you for listening to LexTalks. Follow, subscribe, and stay notified to never miss an episode.